Vicarious liability is where employers are held responsible for the actions of their employees, and these actions which are carried out in the course of employment. Now, the case of Jones and Tower Boot Limited established that the definition of in the course of employment should be construed quite widely. So this means that there's a risk that employers can be held responsible not only for the actions of its employees carried out inside of employment, but also outside of employment as well. And social media is communication online which takes place via the forum of, for example, Facebook, LinkedIn, Twitter, or blogging. Well, the risks to employers increase as the accessibility and the popularity of online media and social media increases. Employees can often access social media through their IT facilities at work and through private devices such as smartphones. And this actually blurs the boundaries between what is social media in the workplace and what is social media outside of the workplace. So that's definitely a difficulty that employers have to tackle. Employers can be held responsible for, amongst other things, bullying, and this includes cyberbullying, harassment and discrimination if carried out by their employees. And if they are found to be liable for such conduct, they can be subjected to heavy fines, reputational damage, and they may have the cost of expensive and lengthy litigation. Harassment is defined in the Equality Act 2010 as unwanted conduct which is related to an individual's protected characteristic. So this could be, for example, age, sex, sexual orientation, disability, etc. And that unwanted conduct has the purpose or effect of violating a person's dignity, or it creates an intimidating, degrading, hostile, humiliating, or offensive environment for that individual. So in the case of online harassment or cyberbullying, this could be, for example, posting malicious rumours about a named individual on Twitter, or it could be deliberately isolating an individual from a social group online. Yes, the recent Carphone Warehouse case is an example of a case where the employer was found to be liable for its employees' actions. In this case, two members of staff took their manager's iPhone without his permission or his consent, and they updated his Facebook status to say, "Finally out of the closet, I'm gay and proud." Now, the manager wasn't gay, and there was no reason for his staff to believe that he was, and he considered this to be sexual orientation harassment, and he took a case to the Employment Tribunal. The Employment Tribunal found in the claimant's favour and found the employer, Carphone Warehouse, to be vicariously liable for the actions of its employees. And the Employment Tribunal explained that the reason why the employer was liable was that the unlawful conduct took place in the course of employment, it took place in working hours, and it involved dealings between staff and a manager. Well, employers actually do have a defence available to them under Section 109 of the Equality Act 2010, and they can put that defence forward if they take reasonable steps to prevent the employees from carrying out the unlawful conduct. So my advice would be to employers to draft and consider carefully and communicate widely employment policies related to social media. In these employment policies, they need to be clear what behaviour is acceptable and what behaviour is not acceptable at work. They should also give examples of what employees can and cannot do both inside and outside of the workplace via social media. Employers should also consider updating their anti-harassment and anti-bullying and equality policies to ensure that they give examples of social media and what can and cannot take place. They may wish to consider monitoring employee activities online, but they should be aware that in order to do so, they need to get the employee's consent in the first place.